everyone. I'm attorney Aiden Durham with 180 Law Co. in Colorado, and you're watching All Up in Your Business. On this episode of All Up in Your Business, we're going to talk about the biggest mistake that I see single member LLCs making and the things you can do to avoid making that same mistake in your business. But before we get into it, don't forget to like, subscribe, and share, and check the description for links to additional information and resources. All right, so let's cut to the chase. What is the number one biggest, most common mistake that a single member LLC can make? In a nutshell, it's, acting like you're not really operating a business. Thinking that you can just file a form with the state and start an LLC and boom, you are good to go. Nope. Sorry, friends. That's wrong. So the primary purpose, the main benefit of the LLC is that it protects you as an individual from the liability and the debts and the obligations of the LLC. If the LLC is sued and it has some damages assessed against it, those are the LLC's liabilities and not yours personally. At least that's the idea. And this protection doesn't just come from filing some form with the state and paying a little bit of money. You have to actually do things to keep that LLC protection alive. I mean, really, you think just filing a form, one form, maybe a couple of forms with the Secretary of State is going to magically, automatically give you personal liability protection? Not exactly. And people tend to think that just because something isn't legally required, meaning there's no actual law or statute saying that we have to do something, means that we don't have to worry about it. Most, if not all states, I don't know all the laws of all the states, but at least most states, their statutes will say something along the lines of an LLC may have an operating agreement. May have, not shall have or must have. So it permits the LLC to have an operating agreement, but it's not required. And I'm not aware of any statute that says that an LLC must have its own separate bank account, or it must do this, it must do that. Most states, for the most part, are quite permissive when it comes to how an LLC operates. But just because something's not statutorily required doesn't mean that it's not just plain old a good idea to still do it. Because, what's the purpose of even forming an LLC in the first place if you're not going to take the steps to do all the other things that really uphold and strengthen that limited liability protection? What's the point in filing a form and paying that money if that's all you're going to do and you're not going to take any of those further steps that may not be legally required but might still be a really good idea? LLCs aren't this perfect, absolute, impenetrable force that will always protect you. There's this thing called piercing the corporate veil, which, even though it says corporate, also applies to LLCs. A court will disregard the LLC form and hold the individual member responsible or liable for the LLC's liabilities. And this concept doesn't come from statutory law. For as far as I know, again, I don't know all the laws of all the states, but as far as I know, there's no statute that says how and when piercing the corporate veil might happen in an LLC. This comes from common law or case law, instances where a court has decided to pierce the corporate veil and has given us reasons for why that's the just and equitable thing to do. This gives us legal precedent that we can then kind of rely on and say, well, in that case, the court said these factors led to piercing the corporate veil. So we need to make sure we avoid these factors. This case law tells us the circumstances under which piercing the corporate veil might happen. Piercing the corporate veil is often synonymous with this alter ego doctrine. If the LLC is just an alter ego of its members, then piercing the corporate veil might be the appropriate thing to do. Basically, if the LLC is just an instrument for the transactions of the member's own affairs, then that's often going to kind of fall under this alter ego idea. If there's no separateness between the personalities and the interests of the LLC and its members, then why would we need to respect the existence of the LLC? But in many jurisdictions, Colorado included, because that's where I'm licensed and that's what I know most about, in a lot of jurisdictions, it's not just the alter ego that a court will look at. The court is going to consider if the LLC is just an alter ego of its members, but they're also going to take into consideration if the LLC was used for some kind of fraud or deceitful wrongdoing, or to really just defeat an otherwise rightful claim. They'll also consider if piercing the corporate veil will give an equitable and just result in the end. In other words, is this what is going to be fair? Like, if an LLC were sued and the court determined that the LLC is liable to the plaintiff for whatever, if that on its own would result in an equitable and just relief for the plaintiff, then there's no real need to pierce the corporate veil. If the LLC is capable and able of providing whatever kind of relief is ordered, then there's no real need to pierce the corporate veil. So it's not just about holding members responsible or liable for the LLC's liabilities. It's more about making sure the ultimate outcome is equitable with respect to both parties. So it's not just if the alter ego thing exists. There also needs to be some kind of fraud or deceitfulness in avoiding a legitimate rightful claim. And we also need to see if piercing the corporate veil would provide an equitable result that we wouldn't otherwise be able to give. And so this risk of piercing the corporate veil is a lot higher in a single member LLC as it is compared to a multiple member LLC. This is just because the nature and structure of a single member LLC kind of lends itself to abuse, essentially. There's no other members, there's nobody else involved who's keeping an eye on what the single member LLC is doing. It's a lot easier for a single member LLC to take advantage of that limited liability protection. And it's easier for the single member in the single member LLC to not really treat the LLC as its own separate entity and respect that legal distinction between myself as the member and the LLC as its own business. And if you're not going to treat your LLC as a separate and distinct business, then why would a court do so? So what can we do to avoid this? In Colorado, there are 8 factors that a court will take into consideration to determine if the LLC is just an alter ego of its member. Whether the LLC operates as a distinct business entity, whether personal and business funds and assets are commingled, whether adequate corporate records are maintained, whether the nature and form of the entity's ownership and control facilitate misuse by the member, whether the business is thinly capitalized, whether the entity is used as a mere shell, whether the member disregarded legal formalities, and whether business funds or assets were used for non-business or personal purposes. Now, even though these are specific just in Colorado and may not necessarily apply the same way in other jurisdictions, they're all generally good ideas, good business practices to keep in mind and follow, regardless of where your LLC is formed or located. And a court is going to look at the specific facts of each case. It's not like all 8 of these factors need to exist all the time. And there's really no one factor that is especially more important than any of the others. I mean, for example, let's say the LLC member has followed all corporate formalities. They've got an operating agreement. They hold a regular meeting. They keep meeting minutes or meeting resolutions. They do all the corporate formality things we're supposed to do. But They treat the LLC's bank account as their own bank account and they dip into it willy-nilly whenever they want or need. They use business assets for their own purposes. They treat basically the LLC as their own personal savings account. That could be a situation where piercing the corporate veil might be appropriate. But on the flip side, let's say the LLC member didn't really follow corporate formalities. Like I said earlier, there aren't many state statutes that are going to require an operating agreement or require the member have meetings or require that they follow these corporate formalities. So maybe we didn't do that. Why should an LLC or an LLC member be penalized for not doing something that it's not required to do? If corporate formalities have been disregarded, but everything else has been operated properly and rightfully, and in all other respects, the member treats its LLC as a separate business entity, meaning there's no mixing or commingling of business funds or assets. The LLC has, for all intents and purposes, been operated as a distinct business entity, then a court may very well determine that an alter ego doesn't exist and piercing the corporate veil wouldn't be appropriate. I think now is a good time to mention I've got a free downloadable guide on how to pay yourself in a single member LLC. You can check that out and find the link in the description. So the point with all of that is to say there are these different factors that a court's going to look at, but you don't need to follow specifically all of them all the time. Again, not all of these things are legally required for an LLC. And so if everything else is great, but you just didn't do the things that you're not legally required to do, then that may not all the time damage you. And again, like I mentioned earlier, it's not just the alter ego thing that they're going to be looking at anyway. Maybe there might be some factors that kind of look like this is just an alter ego. But if there was no situation of fraud or deceit, or if the LLC is capable of providing some equitable relief that is going to be just and fair in the end result, then piercing the corporate veil may not really be necessary anyway. Again, it's not about holding the members responsible. It's about having an equitable and fair result in the end with respect to all parties involved. So there are a few really common questions that come up when I start talking to people about single member LLCs and piercing the corporate veil. Understandably, when I say that the risk of piercing the corporate veil is higher in a single member LLC, the thing that comes up is, well, should I add someone else to my LLC? Can I add my wife to the LLC? Should I add my kid to the LLC? Can I add my brother to the LLC? What about my neighbor? Can I add my dog to the LLC? Should I just add somebody else's name to the LLC so I'm not a single member LLC? No. Simply adding somebody else's name for the sole purpose of not being a single member LLC isn't really going to avoid that slightly heightened risk of being a single member LLC, most of the time at least. I do have some colleagues in some other states who have said that in certain situations, simply having another name, another member on the LLC can be beneficial. But again, it's all very circumstantial and situational. And so for the most part, just adding somebody else's name to an LLC, that by itself isn't going to provide much benefit or really do any good in most situations. We need to think about the soul of the alter ego doctrine and its ultimate purpose and meaning, not just exactly what it's saying. Let's think about its soul. It's about this. Is this business being operated as a distinct business entity, distinct and separate from its individual members? Is it being respected as an entity that is legally not the same as its individual owner? If you're still not respecting the legal distinctiveness of the LLC and you just throw somebody else in there, what good is that going to do you? I'll tell you, not much. And the second question I get when we talk about single member LLCs and keeping them separate and distinct from the individual owner has to do with taxes. Unless a single member LLC elects to be taxed as an S corporation or a C corporation, the LLC is going to be considered a disregarded entity for federal tax purposes in the eyes of the IRS. Basically, The IRS looks at it as if the LLC doesn't even exist. What? Now, wait a minute. I'm trying to keep everything separate and distinct, and now you're telling me that the IRS treats it like the LLC doesn't even exist? Yeah, that's right. But that's just the IRS, and we're just talking about taxes. The LLC's profits and losses are reported on Schedule C to the individual member's personal tax return. And it's basically taxed as if the LLC's income is the member's income. But just because the IRS is disregarding the LLC doesn't mean that the LLC is going to be disregarded in all other respects. It is possible to have a single member LLC taxed as a disregarded entity, but also still treat your LLC as a separate and distinct business and not fall into this alter ego situation. So the moral of the story is this: you cannot just file a form and pay a couple of fees and form an LLC and expect that on its own to protect you. You have to respect the LLC and honor the fact that it is not you. It is legally a separate, living, breathing being. The LLC isn't just an instrument for you to do business. It is a business in and of itself. And you need to respect that. Because if you don't, then why should anybody else? That's all for this episode, folks. Drop a comment below. Let me know what you think. And again, don't forget to check the description for links to additional information and resources, including my guide on how to pay yourself in a single member LLC. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.